Get ready for dictation. Start. As has been noticed herein before, the appellate court affirmed findings of the trial court and dismissed the appeal preferred by the plaintiffs. Para counsel for the appellants would argue that the appellants, being disorders, are co-sharers. It is further argued that the plaintiffs and earlier their predecessors in interest are recorded to be in exclusive possession of land detailed in para 2 of the judgment of trial court until the change qua possession was brought. Wide order exhibit D1 recorded at the back of appellant's plaintiff. It is argued that vehemence that once the plaintiffs and their predecessors were recorded to be in possession of land in question, both in the Jambandis and Khasra Girdwaris, no correction, alteration in the revenue records could be made by the revenue authorities, much less without giving notice of hearing to the persons affected. It is further argued that the courts have committed a grave error, rather illegality, by relying upon document exhibit D1 and entries of subsequent Khasra Girdwaris that ensued. Order exhibit D1 para counsel representing the respondents has supported consistent findings recorded by the courts with the submission that in the earlier litigation filed in a representative capacity against the state of Haryana and municipal committee, it was averred that Biswadars of Shamlat are the owners in joint possession of land, subject matter of said litigation. Therefore, the courts have rightly relied upon the judgment exhibit D4 to negate plea of the plaintiffs in respect of their exclusive possession of land in question. Para I have heard counsel for the parties produced the paper book and records. Indisputably, the earlier litigation was filed by the proprietors of aforesaid in representative capacity against official defendants, therein claiming declaration with consequential relief of permanent injunction or in the alternative for possession. The said litigation culminated in ex parte judgment and decree dated 21/11/1992. Counsel for the respondents has failed to point out if in the earlier litigation initiated by proprietors the issue in controversy was with regard to joint or exclusive possession of land. This apart, in the concluding para of the judgment, exhibit D4, the court has held that the plaintiffs are directed to be owners in possession of suit land described in para 2 of the plaint. The courts, without correctly appreciating the dispute involved in the present litigation and findings recorded in the judgment exhibit D4, proceeded to record a finding that the appellants are not in exclusive possession of land in question. In this view of the matter, reliance upon judgment exhibit D4 to non-suit the plaintiff's appellants is highly misplaced, thus cannot form the basis to reject plea of the appellants in respect of their exclusive possession of suit land. Stop.